right, fantastic. Okay, well, good morning, everyone, and welcome to Wills Week 2025. We're actually closing out Wills Week today. My name is Lisa, and I work with the Edmonton Community Foundation, and I am your host for today's webinar. I'm hoping that you have seen a few other sessions or have been to some in-person sessions. We put on 9, this being the ninth, and it is only made possible thanks to some amazing volunteer lawyers and tax professionals like Mike and Allison, who are here to guide you in the proper preparation of your estate plans. Understanding the hardships and additional costs that occur when these estate documents are not in place correctly will help you to appreciate the value of getting professional help for you and your loved ones. Edmonton Community Foundation is pleased to provide Wills Week as an important resource for Alberta-based will and estate information. It unites our role as a trusted partner to help people create a legacy for their community. At ECF, our expertise is endowment funds, contributions that are invested and provide ongoing support to enhance our community during and after our lifetimes. To learn more about these funds and affordable options of how they can help you save taxes, please visit our website at ecf.ca. In our work, we see a lot of wills, and we understand how powerful these documents can be. We want everyone to benefit from the Wills Week sessions and understand how professionals can make your will more effective and accurate. If you have any questions during this presentation, you can type them into the Q&A box. We will monitor them. To find that box, if you haven't already, just go to the bottom of your screen. There's a chat and a Q&A, so please use the Q&A. We'll answer as many of these as possible during the presentation, and note that we'll try pretty much only addressing general questions with respect to the session to protect your privacy, and in the interest of time, we won't be able to answer case-specific or information-sensitive questions. I need to advise you, as I have, that this presentation is being recorded, and it will be available on our website within the next week. At the end of the webinar, please take a moment to fill out the survey. It should appear on your screen. We do read them. We take them importantly. We do use the information to help advise Wills Week sessions in the future. So now it's my pleasure to introduce our presenters today. Michael Simons is a lawyer who believes legal advice should be clear, practical, and dare we say enjoyable. As a partner at McQuaig DeRoche LLP and chair of the firm's management committee, Mike spends his days untangling corporate knots, calming estate drama, and making real estate deals feel less like cliffhangers. He's also a go-to for families navigating the delicate art of succession planning, helping pass the torch and the farm and the business without lighting any fires. When it comes to estate law, Mike brings empathy, experience, and just enough humor to keep things human. He's been through the process himself, so he knows how to keep the peace, or, when necessary, how to win the war. If there's a dispute, he's ready. If there's a will, there's a way, and Mike will help you write it. He's a strong advocate for proactive estate planning, and he's not afraid to say that your someday file deserves a little attention today. Allison Barkwell practices in all areas of estate planning and administration, including contested matters. Her wealth of experience provides both cautionary tales and best practices, often summed up as what not to do and how we could have prevented this mess. She believes in a practical, solutions-focused approach and strives to use plain language in all her drafting, making complex legal concepts accessible and clear for her clients. Like her co-presenter, Allison brings a sense of humor to her work, helping to make even difficult conversations about estate planning more approachable. She encourages clients to be proactive, often reminding them that no plan is still a plan, just not the best plan. Outside the office, Allison enjoys spending time outdoors, whether she's on the golf course or running in the river valley. Well, we are very pleased to have you both come back after every year. We appreciate your time, and I am going to pass my torch over now to you.
Thanks so much for having us again. How you doing, Allison?
I'm doing okay. I'm recovering from a bit of the stomach flu that's going around. So,
Well, I'm sure glad we're online. Uh,
Mike, you don't want it? It's a gift that
no,
you
no,
give it.
I'm going to pass on that generous offer.
Okay.
Dare I say that the ECF has saved the best for last? on Will's Week, or should I say, we have the toughest presentation because we've got to answer questions on the fly, and it's not a pre-canned one like we've done every other year. But I'm looking forward to today.
I'm looking forward to today too. Mike every year is on the fly with us, so
That's true.
this is nothing new.
Fair comment. Fair comment. So, just as a bit of a preamble, and obviously you heard a little bit of this before, we're giving general information, not legal advice. Today, the other thing that Allison and I have uh, knowledge in is how taxes interplay with the states, but we are not tax specialists. We're not accountants. And so any discussions about tax scenarios should be taken only as information as well. And I always say that a good accountant is worth paying for to stay out of CRA's crosshairs. So Alison, do you want to just give should we give the 30,000 foot view of a basic what an estate plan is?
Sure.
Why don't you lead off?
Okay. So estate planning, when Mike and I talk about estate planning, consists of three documents. We have the will, which is where your stuff goes when you die. We have the enduring power of attorney. The enduring power of attorney is a document that may come into effect while you are alive. And that document is the document that allows the person appointed as the attorney, not a lawyer, to make financial decisions for you. So, this is a person that would be paying your bills, dealing with your investments, filing your tax returns. And finally, we have the personal directive. And the personal directive only comes into effect upon loss of capacity. And that document is the document that allows the person to make healthcare decisions for you. Also, decisions as to where you would live, what sort of treatments you would receive, and who you can associate with, which always seems like a funny one, but there's lots of predators out there, which I have seen a lot of in the last year. So that is the basic overview of the three documents. Mike, why don't I let you start on what the contents of the will are?
Sure. And maybe I'll also let people know that we have a bad habit as lawyers of using abbreviations. So for an enduring power of attorney, we say an EPA. For a personal directive, we'll often say a PD. And as Allison mentioned, the person you appoint under a personal directive is an agent. Person you appoint under an enduring power of attorney is an attorney, not to be confused with your lawyer. In the United States, they use the word attorney for lawyer, but in Canada, we're not attorneys, we're lawyers. And for the will, when you appoint someone to handle your matters after death, that person we have a couple names for, unfortunately, either a personal representative or sort of the more common term is an executor, or sometimes we call them a trustee. And you can blame whatever level of government you'd like for that. They've changed the nomenclature over many, many years. But I generally use executor just because that's the one that people are most familiar with. And so when you're doing that will, one of the big questions is who you appoint to be your executor, who's going to handle your affairs after you die. I think Alice and I have a common practice that we would appoint at least one alternate and sometimes two alternate executors, sort of a succession of people in case someone's not available. And generally speaking, you our strong preference and the advice accountants give is to appoint an executor who is a resident of Canada. That is because when someone dies, all of their assets vest in that executor, which is why sometimes we call them a trustee. And the challenge of having a non-resident executor is there can be some very negative tax consequences. And so that is why generally most estate planning lawyers will recommend a Canadian executor. Now, whether they're in or outside of Alberta is more of typically a function of practicality and proximity more than the other matters. There are some advantages to having an Alberta executor, but we won't get quite that granular. And then your will essentially says where you want everything to go. So often there will be specific gifts or specific bequests. So I want Allison to have my silver tea service. I don't have one, but and I would say this goes directly to Allison. And so specific gifts come off the top. And then whatever's left is called the residue. And the residue is, I always talk about pieces of the pie. Who gets how big of a piece of the pie? So for a lot of people, it'd be everything goes to my spouse. And then if my spouse predeceases, everything goes to my children equally. So if there's two children, three children, then typically it would be divided equally between those children. And that's the residue. The other important thing that people will put in their will if they have minor children is a guardian for those minor children. The default guardian is the surviving spouse or parent of those children. And then the law allows you to say who you would like to be the guardian of your children if both parents are deceased. And obviously, that is an important decision to make. I also find, Allison, it's often the decision that stops people from finishing their estate planning because they can't decide between this person and that person.
I've had one couple and they have changed their will 6 times so I think
Yep.
every family vacation, something happens and they come back and they decide, no, whoever is in second position needs to move to first and whoever was in first needs to move to second.
Yes. So that's the basics of a will. Obviously, a will can be as simple or as complex as the circumstances, the people, and the assets dictate. Sometimes there will be a disabled child that needs to be taken care of, or somebody who perhaps has addiction issues. And I don't think our purpose today is to get that explicit, but with just an overview of a basic will for somebody for their estate plan. Allison, do you want to go through the basics of an EPA and PD?
Sure. So the enduring power of attorney, that's the document that allows financial decisions to be made. Again, similar to a will, you appoint one person potentially to be the attorney, and then I always suggest having an alternate or alternates, just in case the first person who is acting is unable to act. With the enduring power of attorney, it can come into effect immediately upon signing it. So you can sign it so that once you sign it, it is in effect and the attorney appointed can begin acting. For these situations, it's usually a situation of an elderly person who does not want to go to the bank anymore, or there may be some mobility issues and the person just needs some assistance with paying their bills and they've asked the attorney to begin acting. I do tell clients in that situation where they've brought it into effect immediately that they can fire the attorney at any time if they still have capacity. So they are still in charge of their assets. It's just they're getting some assistance from the attorney acting. The other way the power of attorney comes into effect is upon loss of capacity. And then in losing capacity, the legislation states that two doctors bring it into effect unless you have something different in your documents. In the current state of our healthcare system, I am finding clients are having more difficulty finding two doctors to sign a declaration. Some clients now are more comfortable putting in one doctor, but it's really up to the person making the document as to what they want. So once the power of attorney in the contents of the document, then it states all the powers that the attorney has. And essentially, once the power of attorney is in effect, the attorney steps into your shoes in their ability to deal with your bills. So they can pay all of your bills, file your tax returns, deal with your investments. But where attorneys tend to go offside, and Mike, I'm sure you've seen this all too often, is that the attorney can only use your money for your benefit and the benefit of your spouse, unless there is something different in your power of attorney that allows them to do so. So where I tend to see attorneys go offside on documents is in the gifting. And they say, well, grandma always gave $50 at Christmas and $25 on birthdays. So as the attorney, I continue to do that. But if the power of attorney doesn't say that you can continue gifting, you can't gift or gifting to charities. So any sort of gifting needs to be listed in the document. The document itself lists all of the powers that you have as the attorney. And if it doesn't state something that you can do, you can't do that as the attorney. Um, Finally, the power of attorney can have a compensation clause, and that is really up to the person who is making the power of attorney at the time, how they want the attorney to be compensated. Um, there's different viewpoints on this, and some just want them to receive a monthly amount for acting. Any money they do receive as compensation is taxable; it's deemed to be income. And finally, what I've been a bigger fan of, just seeing all the elder abuse I've seen on my files in the last few years, is requiring the attorney to do an accounting on an annual basis to certain parties, just to ensure that there is transparency. I know Mike has his famous line from Professor Hop, just to ensure that there is transparency between the parties and that the parties continue to have a relationship after the person is no longer around. The next document is the personal directive. So the personal directive is a document that allows healthcare decisions to be made and personal decisions to be made. This, you appoint an agent to make decisions, and then if they're unable to act, you can appoint alternates. With the personal directive, this only comes into effect upon loss of capacity, and similar to the enduring power of attorney, the legislation states that 2 doctors bring it into effect unless you have something different in your document. And that's really the choice of the person making the personal directive. So once the personal directive is in effect, the person can make decisions with respect to your health care. So what sort of treatments you would receive, end of life decisions as to when life support should be withdrawn. It would also have who can also have access to medical records and speak to doctors. In addition to the agent or agents not acting, you may have other family members that you want to be able to speak to doctors if you've lost capacity so they understand your condition. And then finally, I ask clients what their wishes are with respect to staying in their home if they're unable to care for themselves, so that the agent appointed respects decisions if you're okay being moved to a long-term care facility or if you want to stay in your home as long as possible and use your assets for that, for ensuring that you receive appropriate home care. The personal directive also, the agent appointed also should have access to what's called your green sleeve. I do see we do have a question about your green sleeve or your goals of care, so that the agent understands what your wishes were with respect to your healthcare when you still had capacity, and they can carry out your wishes with that.
That's a great point, Allison. And one of the things I like to say, and it covers off one of the questions, is a will is just a piece of paper until someone dies. Whereas an enduring power of attorney and a personal directive are what I typically call living documents. They impact a person during their lifetime. So one of the questions online is the bank wants me to give them a copy of my will. Is this a good idea? Well, I mean, it's up to you if you want to, but I generally would advise against it. It's none of the bank's business what your will says, and your will, again, is just a piece of paper until you die. So it might change, like Allison's client, 6 times over 5 years, changing guardians, etc. So I generally wouldn't give the bank a copy of my will. Allison, do you agree?
I know there's no reason for the bank to need to, there's no reason for them to see it. It's your will, and again,
Yeah,
you can change it up until the moment before you pass away.
exactly. And on the green sleeve question, uh, I always talk about a personal directive as sort of the 30,000-foot view. It gives some general guidance on what type of decisions you want made, whereas the goals of care, which is a medical document filled out in assistance with doctors, sets out on a really, really ground level the different type of treatments you are willing to accept. And it goes, I think it's RMC, which is resuscitative, moderate, and comfort care. And so The thing to remember about that personal directive and appointing an agent is what you decide when you're someone as young as Allison and what you decide when you're someone as old as me might be completely different. Lisa, I'm not sure how best to go through these questions. I know we had some sent in advance, and then we've got a whole bunch online. Do you want to read out, sort of go back and forth with the ones in advance and then the online ones?
Sounds good to
And
me.
okay, and I just have one more comment about the enduring power of attorney and personal directive. Um, just what I've seen in my practice in the last few years, sometimes you have a different person acting as the attorney and another person acting as the agent. Sometimes there's disputes between the parties. I recently had a file where there was a dispute on there was a gentleman who needed new dentures. He was terminally ill but wasn't able to eat any food. So one child was acting as the attorney, the other child was acting as the agent. The agent went and got her dad new dentures because he needed them to eat. And the son, unfortunately, who was acting as the attorney and knew what was in the will, said no, he wouldn't reimburse his sister for those expenses. So in my documents now, I just put who has the final say in case of there being a dispute. In my opinion, I would always pick healthcare over finances, but that's my own personal opinion.
So I
Great.
think that's a great point, Lisa, Allison. Lisa, I think the first question that came in advance was about charitable donations.
Yes, it was.
And it says, I'm planning to donate part of my estate to charity. Am I correct in assuming this donation will reduce the amount of tax my estate will have to pay? And apparently, this person is very generous because they're asking if so, and if there's any tax credit left over in my donation, and it's more than needed to reduce my estate taxes to zero. Can my heirs apply this credit to their personal tax return, or can it be used in some other way? And generally, that charitable donation, again, not an accountant, but generally, that charitable donation would be used to reduce the tax burden on the estate, but an excess of that is not able to be carried over to the beneficiaries. There can be some creative workarounds in an estate plan if someone has that significant giving where they can do sort of layers of giving to charity and to individuals. And so that to get that tax credit, you would have to, and it's a little challenging, apportion what's going to be needed for the estate, then bequest the amount to the beneficiaries for them to do their own charitable giving and take advantage of that tax credit. Um, that's really the only workaround I could see. Allison, any thoughts?
No, I would agree with you on
Okay.
that. And
Okay, Lisa,
sometimes,
over to
depending
you.
on the accountant, there could be something else
Yeah,
creative,
the
but we're not.
accountants are always coming up with creative things to do with CRA.
So this, just along the lines of debts in this case, the question is, should there be debt when a person dies and no assets? Then are the beneficiaries or executors kind of liable to take that over?
This is a great question. Um, I always hope that the last check I write bounces, but unfortunately, that isn't always we don't have crystal balls and we don't know when we're going to pass away. But in the case where the estate has more debts than assets, this is a very tricky situation for the personal representative. The personal representative of the estate needs to be cognizant of the fact that there's basically three creditors in the estate. First of all, they are the personal representative. Um, they are entitled to be reimbursed for reasonable out-of-pocket expenses in acting. So that would be any legal fees they've incurred, any expenses they have incurred related to the estate. Secondly, the second creditor is CRA. In estates are the only time that an individual is above CRA. So CRA, those debts need to be dealt with. So And then thirdly is general creditors. So when dealing with the estate, the personal representative of the estate needs to be careful that they don't choose one creditor over another. They would need to pay whatever debts are owed to them first, so any legal fees or accounting fees for dealing with the estate. And then secondly, whatever assets they have would need to go towards paying any taxes owed to CRA. Finally, then you're dealing with the general creditors. If the personal representative were to take the money and pay out one creditor for a debt owing of $20,000 before paying the taxes, then they can actually be personally liable to CRA, meaning CRA can come after them for all debts owing. So it's a tricky situation, but it can be navigated, and with the help of proper legal advice, you can work through the situation. We've unfortunately dealt with this probably more often than we talk about, but
Yeah.
it's just navigating it so that there's little risk to the executor who's acting.
Well said, Allison. I know some people may have heard this, but if we are a common law jurisdiction. If you are a civil law jurisdiction, like in France, it's very different. And if you take the role as a beneficiary, you can be liable for debts and taxes owed by the deceased. So there's much more common when that happens, where someone will disclaim their entitlement because they're worried about these debts. But in Canada, as long as you're navigating it properly, as Allison said, generally speaking, you're not going to be on the hook for those debts. There was a question that came in ahead of time talking about when you have someone to be an executor, but you don't have someone to be an attorney under an enduring power of attorney or an agent under a personal directive, what you can do. And it's a tough question because there are what we call professional executors and attorneys. So, excuse me, a trust company, most of the major banks have trust companies that can be hired by a person during their estate planning to be appointed as an executor or an attorney under an enduring power of attorney. However, a trust company will not act in the role of agent under a personal directive because it's not a professional decision, it's a medical decision, and that is something that is much more personal. And I suspect also would be potentially much more risky for a trust company to take on. Allison, do you have any solutions for that?
I recently had a client who had a similar situation. She appointed a professional trust company to be her executor and her attorney. But for her personal directive, she didn't have anyone, and she ended up asking her dentist to be her agent, and the dentist agreed.
Well, all my dental clients will be really excited to hear that.
I
That's
had
interesting.
I had about 3 conversations with the dentist so she could understand what
Yeah.
was the role, but she was comfortable agreeing to this for her client. The other option, I guess, would be asking the office of the public guardian to be the agent, but they would need to agree to the appointment.
Yeah, and my experience is that they are so short-staffed that they are not very agreeable to that. But
No, I know.
yeah,
It's an unfortunate situation.
yeah. Lisa is another one from the chat.
Absolutely. So there's actually a lot of questions around compensation for your executor or your power of attorney. So I wonder if you can just speak broadly around like the parameters or how we compensate or do we compensate these people, these individuals?
Yeah, it's I'll talk about executor, which is probably a little more common than enduring power of attorney. Um, an executor is entitled to be paid for the work that they do in dealing with an estate, and uh, there is no specified regulation saying what they are entitled to. There is a guideline that was published many years ago, and which the courts have fairly broadly adopted, but it is not set out in a statute anywhere. So the alternatives are when making a will, you set up what an executor is entitled to be paid, or if you don't have something in the will, then there's sort of these essentially default rules. And the default rules generally, and this is a very 30,000-foot view because everything is going to be depending on the circumstances, are that an executor is entitled to a range of between 2 and 5% of the value of the estate as fees. That percentage generally goes up with the complexity of the estate. And every executor thinks that the estate they've worked on is the most complex one they've ever worked on, or they will ever work on. But it takes a fair amount of complexity to get to that top level. The other thing that people are typically not aware of is that those executors' fees are employment income. So it is reported as an income by the executor. It is also required that the estate make remittances for such things as EI and CPP. So there's some paperwork and red tape that has to be dealt with when doing those fees. And for example, I had a file recently where somebody was determined to claim executor's fees, but they didn't want to take very much, and it was just them and their sibling, and they were going to take, I think, $10,000 or $20,000. And I said to them, okay, that's fine, but the thing you have to remember is, so half of that money is yours because you and your sibling are the residual beneficiaries. So if you don't take executor's fees, if it's 20,000, you're already getting 10. If you're taking the executor's fees, you're losing that 10 as a beneficiary, and you're paying tax on it, which you're not as a beneficiary, and you're making remittances. So they said, nope, I won't take them, off to the races. Allison, what do you think about that?
I agree with you, Mike. Yeah. Are
And
you okay?
yeah, sorry, allergies, fall allergies kicking in. What about
Yes.
attorney fees, Allison?
Attorney fees, there is the guidelines of the under the Trusteeship Act, and I think is it 2% or whatever it is. The attorney fees, I prefer when the clients are actually doing the documents that they put in the attorney fees. I if and that the attorney get a monthly amount. With the attorney fees, I do suggest that putting a higher fee for the first 6 months that the attorney is acting, because that's usually when most of the heavy lifting has to be done. They need to go to the banks. They need to provide everyone with the power of attorney, sign all the appropriate documents. If the house needs to be listed and sold, then they can do that at one time and then begin to consolidate the assets into one pool. Because sometimes people have have assets at all sorts of different banks. So it's really, from a planning perspective, I would suggest it's something you put in the document to begin with, so
And
that
that's also taxable? Like
it
that's
is.
also income? Yeah. Okay.
Yeah, it's an area that isn't talked about enough or contemplated enough often when people are setting it up. And I think that until someone has the luxury, privilege, or burden of acting in those roles, it's hard to appreciate how much work it is, and time and effort and potentially risk as well.
Yes, and with the power of attorney, it can be going on for potentially several years.
Yeah.
Um, so you don't know how long they're going to be acting. I know some banks, once the power of attorney is in place, the attorney doesn't have access to online banking. So anything they do, they need to actually either physically attend the bank to get a bank draft, or they need to be able to write checks. But also, they're waiting for the bank statements to make sure that everything's okay when they're paying bills. And with bills with respect to home care, those are can be significant.
Good point. Um, there's one of Allison's favorites that came in ahead of time, an
One of my
opinion on
favorites. Oh, good.
online wills.
I love online wills.
Why do you love online wills, Allison?
It just means, oh, no, I don't love online wills. Online wills, I recently looked at an online will and it was terrible. I know you're shocked, Mike.
No.
Um, and I think people like the convenience of the online wills, but usually they're missing something. In this particular will, I saw it was missing the residue clause. That means where does everything go? Um, After all the bills are paid, they've given some gifts to everyone, and then the residues, what is left in the pool of money? Where does that go? So that was missed. And so when I told the clients, well, because you've missed this residue clause, your estate would go to these people. And they're like, well, we don't want that. And I'm like, well, that's what your will says. And usually, Mike, I don't know if you found this in your practice, people usually sign the documents wrong.
Yeah, it's there are legal formalities of signing the documents which lawyers are very, very careful to follow, and people are less careful because they just don't know. And The world has become much more informal, and so I think a lot of people just sort of are DIYing. I mean, I can go to Home Depot and pretend to be an electrician, but when I shock myself pretty hard, I find out I'm not an electrician. And so I think there's a whole DIY culture out there. And, it's I think that you can save a little bit of money and cost your estate a ton of money doing one of these. And there are just some very basic things that an online will doesn't contemplate. An online will doesn't look at the title of any property you own and consider how the title is held and if that needs to be dealt with in your estate planning. An online will doesn't look at your investments, RSPs, TFSAs, life insurance, determine if you have designated beneficiaries, determine if you're going to do something like say, oh, child A gets all my RRSPs and child B gets this bank account. And then, as Allison knows, child A gets all the RRSPs and all the tax on those RSPs coming out gets paid out of child B's bank account. And all of a sudden, you've just not given equally to your children who then blame each other and never talk to each other, and all because you saved money with an online will. I mean, there's a lot more that goes into estate planning than just the paper. And
And
I
it's
think,
also, yeah, also understanding the relationships between the parties. Because I know people are like, well, I don't want to pick one child. I'm like, so I want to name them both to be the executors. Like, well, what's the relationship like? Well, they haven't spoken in 10 years, but I think they can do it.
yeah, that's going to be the thing that heals the wound. Yes.
Um, yes. So when you appoint more than one executor, so if you appointed your two children to be the executors of the estate, they would need to be unanimous in all decisions. So if they haven't spoken in 10 years, what are the chances they're going to agree on anything?
Yeah, absolutely. Lisa, do you want to throw one out from the chat?
I will. Actually, there was one as well about online wills, but I'm assuming it's the same feeling about will kits.
Yeah, same thing
Yeah, same
essentially.
thing.
Yeah.
Okay. There's a question about reviewing. So they're just saying to save time and money, can a lawyer review a will that I've written myself, or do you insist on using it like your own template, or what is the benefit of either of bringing in one you've done yourself?
Yeah, I'm gonna be honest. I don't even like reviewing other lawyers' wills. So, and part of the reason is um, doing the estate plan as a lawyer is an investigative process. I mean, we ask our clients for a whole bunch of information, and that there's two reasons for that. One is we need to know what there is to contemplate. But the second one, and the one that people don't talk about, is that we need to know that the person making the will knows what they have.
Hmm.
And through that process, very often someone will say, oh, yeah, I had some shares in, I'm going to date myself here, AGT, which became TELUS, but I've never dealt with them before, et cetera, et cetera, et cetera. And so there's that whole sort of investigative, exploratory process that lawyers follow. So to review a will for just the, does it have all the clauses it needs to have? Was it signed properly? Well, we can't tell that based on a will. We don't know how it was signed. We can see signatures, but the legal requirements are that all the people signing the will are in the room together at the same time and see each other sign. So doing all of that, I mean, bluntly, will probably cost more than doing a new will, in my opinion. Allison, do you ever
I,
review?
I've been asked to review wills, and I'm always very uncomfortable because I don't know what I don't know.
Yeah.
So I can read something and be like, I have no idea. From a legal perspective, it might look okay, but you don't understand the relationships. There could be a disabled child, it could be a second marriage. You don't know what's happening.
Yeah, I mean, one of the things, and there's lots of case law on this, is I want my one child to have this property, except that property isn't owned by the person, it's owned by their company. And a person doesn't own what the company owns, they own the shares in the company. So they didn't give the shares to the child, they gave a property they don't own, and that gift fails under a will. So to look at a will and say, oh, they want this child to have this property, well, I guess that'll work. But if we don't know that the property is owned by a company, then the will's not going to work. So generally, and I appreciate for the folks watching that, it's like saying to a mechanic, do I need you to change my oil, or can I do it myself? Well, you can do it yourself, but when you get covered in oil, you'll be back to see the mechanic, right? So the problem here is when you're covered in oil, the metaphor doesn't really work. Well, you're gone, and it's too late to fix what you've done.
Right. I just say it's, do you want your GP to do open heart surgery? Probably not.
Yeah. So before the advanced questions, this was kind of an interesting one. It was interested in information, tips, planning for a person that is single, i.e., no family, no dependents. Um, I think generally, um, one of the things we talk about in Alberta is testamentary freedom. A person can do with their estate what they want, subject to their legal obligations. And people have legal obligations to spouses, minor children, children over 18, less than 22, or at 18 to 22 in post-secondary, or adult children who are unable to earn a livelihood due to a physical or mental disability. So if you're a single person, not married, no kids, no obligations, essentially you can do whatever you want. And the tips and tricks would be, do you have to have a will? No, because you'll be gone. But you're kind of leaving a mess for whoever in your family has to deal with it. And the enduring power of attorney and personal directive, again, even more important because when people don't have those documents, then it's not just a set of default rules to distribute your estate, it's court applications and significant time and money to have someone appointed to make those decisions for you.
It's also with all of our privacy legislation, no one will talk to you without the documents or without, in the case if there isn't a will, no one will talk to you without the grant from the court, say that you have the authority to act. So if you're trying to pay bills or do anything, no one will talk to you. And it's really difficult. It's really frustrating. Especially, I know I'm dealing with a parent who lost a child and the child didn't have a will. And first of all, they shouldn't have to be dealing with that. And then every time they try and do something for the estate, they have no access, including cleaning out the child's apartment. The landlord was not going to let them in to clean out the child's apartment.
And
So
the
it's
other
really,
one is the digital assets, right, Allison?
oh, yes.
I mean, if you don't have a will that has a clause that gives the authority over to digital assets, and you keep getting friend requests from your deceased child or friend from Facebook or whatever they're using. I have an old friend who passed away, and I get every year a LinkedIn notification about his work anniversary. Well, he's
You
not
can
working.
LinkedIn will remove it if you send them.
If somebody does it, but the
Yeah.
executor has to do it, right?
No, it's not the executor. I've done on other ones
Oh,
where
really?
I've just sent in the obituary or whatever, and
Ah, good to
yeah,
know. Look at that.
yeah,
I learned something today.
yeah. No, I did one on one because I kept receiving. I was like, they died about a year ago, so I LinkedIn will actually remove them.
That's
I think
interesting.
LinkedIn is the only one, but
Yeah.
still helpful.
Lisa, more from the online?
Absolutely. So this I thought was interesting. It says, who, if anybody, oversees the executor's decisions, actions, and activities to ensure that they conform to the terms of your will and does not enrich themselves? Does the executor report to anyone?
Yes, the executor reports to the beneficiaries of the estate. The executor basically, once they're appointed in the role, needs to be completely transparent with the beneficiaries of the estate. They do need to provide a complete accounting on the estate of all the money in, all the money out from the date of death to the date of distribution. The beneficiaries will then sign a release confirming that they believe what the executor has done is good and that they're not going to sue them.
And if they don't agree with it, then they hire a real aggressive lawyer like Allison, and then they go to court and
Pass it
say,
down.
court, we want some more information from the executor, and we want, there's something called an informal accounting and then a formal accounting. And so an executor has personal liability if they don't follow the terms of the will. I see we have a whole bunch of questions, both in advance and online, about replacing executors who predecease or the like. And that's part of the reason I think that Alice and I both will have and encourage people to have sort of multiple alternate executors. My preference is to have three choices. That said, I also tell my clients that they should be updating their estate plan or at least reviewing it every 3 to 5 years or upon a life event happening. A birth, a death, an inheritance, a lottery win. And so you can change an executor after the fact in um, I'll call it the old days when you were updating a will to change an executor, we would often do something called a codicil. A codicil is basically like I'm just going to fix one or two things in the existing will. I don't know this to be true, but I often tell people that the reason they would do codicils is back then, and I still probate some of these wills, they do the wills on the onion paper with the carbon sheet behind on the typewriter, and nobody wanted to retype an entire will.
Isn't that how you do your wills, Mike?
And blood. I poke the finger, and yeah,
Perfect.
yeah. But nowadays, with everything on our computers, it's fairly easy to update a will. You can still do a codicil, but I generally will just do a new will. And the one advantage of doing a new will is if Allison's client keeps changing who's going to be the guardian, and you keep doing codicils, you have a record of them. I don't like this person. Now I like this person. Now I don't like that person. Whereas if you do a fresh document when you're doing that, nobody sees that they've made a change. So, I mean, that's generally how I deal with replacing executors. There was also a question about having an executor from the United States. And we
Yes.
talked a little bit about that. Um, I had a client who wanted very much to do that, and they got some tax advice, and they were determined that they were going to name their child in the United States. And the tax advice came and told them that they could do that, but they would pay $1 million in tax extra on their estate. All of a sudden, they were less determined to name their child in the United States. So it's the tax consequences. Well, before the beginning of this year, it was only the tax consequences that were the reason. Now there might be other reasons you don't name some of the United States.
What are you talking about, Mike? What's going
I'm
on?
not
Did
going
I
there.
miss the news?
I forgot my red hat at home. Uh,
I must have missed the news. I better start
yeah,
watching.
exactly. Exactly. Lisa, anything else from the online questions here?
Well, there's this question about the attorney versus the agent. So if they do not agree, who takes precedence?
So it needs to be in the document.
Okay.
And that's where not all, again, not all documents are created equal. I've been pushing clients now more and more to say if there is a dispute, who has the final say? And I gave the example earlier of my client who needed new dentures.
Right.
Yeah.
Okay.
Uh, in the advanced questions, we had a very good question talking about a vacation property in BC that they wanted to lend to Allison. No, no, and me. Yeah, no, a vacation
Perfect.
property and whether they needed a BC will to cover who would inherit that. Allison, do you want to talk about multiple wills, jurisdictional wills?
Sure. So one, you just need, did you know in Saskatchewan you can only have one will?
It's a pretty simple province. I think it could get complicated.
So in Saskatchewan, you're not allowed to have multiple wills. In Alberta, you can have multiple wills, but I just found that interesting. Little fact of the day.
Yeah,
Um,
I learned two things.
Look at that. Wealth of knowledge, Mike.
Tell you.
Your will should be able to cover, if you have an Alberta will, it should be able to cover all of your assets or wherever they're located. Depending on some aspects, if you had assets in some foreign country that we weren't so familiar with, I would suggest maybe having a second will to deal with the assets in that foreign country. In Alberta, if you had your will, it would cover all of your assets. If you had specific wishes with respect to the BC property, that could be dealt with in your Alberta will. With upon death, though, there would need to be a grant of probate in Alberta, and the grant of probate would be the application to the court to have the will verified and that the executor has all authority to act, and they would be able to deal with all of your property in Alberta and all of your bank accounts wherever they may be. But then there would need to be a resealing of the grant in BC. The resealing of the grant would be based on the value of the property in BC. I should go back. In Alberta, the maximum probate fee payable to the government of Alberta is $525. So that would be for your grant in Alberta. Unfortunately, in BC, they are not as like-minded as us, and the probate or the fee for the resealing of the grant in BC would be 1.4% of the value of the asset. And that is payable to the government of BC before the grant is issued.
And the question, I think, was generated by whether BC would charge that on the value of the estate or the value of the asset. And as
Right.
you've identified, it's on the value of the asset. I have, though, had clients who have properties in the United States, and we have done multiple wills. And part of the reason for that, because you can do the same thing, you can get probate here.
Yeah.
I've had an estate where we got probate here, and I had to get a lawyer in Nevada and reseal the estate into the United States. I think I had one in Texas as well. The challenge is when you do that resealing, that jurisdiction gets to see the value of your Alberta estate, and they get to know what the inventory was in that application. And there are people who like to keep those things private, and they don't want the IRS to know what their Canadian assets are. And so, very often, in those circumstances, and sometimes this is with higher net worth clients, we will do these multiple wills. However, there is a significant hurdle that needs to be dealt with between the lawyers dealing with it. And that's because pretty much every lawyer in North America, the first line of their will says, I hereby revoke all previous wills. And so when we're doing that, we need to make sure that both lawyers qualify the documents they're preparing to say, I hereby revoke all previous wills except for the will I made in Las Vegas on January 1st, 2025, which applies to all of my assets in the United States. And so it needs to be coordinated in that manner. And then, of course, Allison, I know you're aware that in Ontario, um, there are a lot of people doing dual wills, where
Correct.
they'll do one will that deals with assets that have to go through probate, and they'll do one will for assets that does not have to go through probate to avoid paying the fees that Ontario was charging them. Luckily, Allison, as we like to say, Alberta is still the best place in the country to die.
Yes. And then in Arizona, I know you can do beneficiary designations on property.
Yes, but you need tax advice.
Yes,
I
but
have
that is an option.
I have some questions here about, and it may be simple, but I think really important. Kind of, what do you do with these documents once you already have, like, you have a will and you have here, like, who needs to know about it? Where do you keep it just to be able to enact it? There was somebody put a situation in here about someone having a stroke, but I think if you have, um, a personal directive, do you need to inform healthcare providers? Like, where it happens to those documents once you've already.
So that's a great question, and so it depends on the lawyer you're working with and the law firm, and I get to plead a little bit of ego here. So uh, different law firms do different things. Our law firm, when you do the documents here, we keep the original documents in a fire vault in our office. And I have the luxury of doing that because our firm's been around since 1895, and it's not going anywhere. And when I'm gone, there's going to be someone else taking over from me. So we're able to offer that as a service to our clients. When we do the documents, generally when we report out to clients, we will send them photocopies of the will, photocopies because they're just a piece of paper until someone dies, but we'll send notarial copies to them of their enduring power of attorney and personal directive. And the reason we do that is the notarial copies are generally accepted by most places that you would use it. So banks, financial institutions for the enduring power of attorney, doctors, hospitals for the personal directive. And we also, when we send out that package, we have a little, I'm making this sign, a little wallet card that we send out that says that the person has a personal directive lodged at our office so that if they're in an accident, the hospital is able to know that there's a personal directive here. So that's our process. Now, that said, I also tell clients don't take the documents and go stick them in a safety deposit box
Please
because,
don't do that. It's a
yeah,
terrible idea.
yeah, because the only person that can get into it is the person or their attorney who needs the document to get into the safety deposit box. So uh, I am a big proponent of transparency. As Allison referred to our old law school professor who used to look over his glasses and say, silence equals suspicion, Mr. Simons. And I'm a big fan of saying to clients, look, you've got these documents, you've appointed people, you've asked them to act in those roles. In my opinion, you should give them copies of the enduring power of attorney and the personal directive. So if something happens, they have them to use. And unless your will has some sort of, I don't know, dramatic thing in it, I'm also a fan of being upfront with people about what's in the will because what's there is never as bad as what people are guessing is there when they don't know.
Completely fair. Our office, my practice is the same as Mike's. I prefer to keep the documents because sometimes they get misplaced or things happen. And so I do keep the documents. We also digitize the documents just in case there is a fire because you never know. But at least I can say that they were lost in our office. And then we Also diarize our file for 5 years and just send a note to say, it's been 5 years. Is everything still okay? Because again, as Mike alluded to earlier, life events happen and sometimes people don't take a look at their documents.
Mm. I like that idea of the card, Mike. So even if we made our own, like if we were working with an attorney who didn't provide that or a lawyer that didn't provide that, just even to have a note, kind of like in your phone, you have your ICE number, your in case of emergency
Yep.
number, right? So similarly, um, that's great. Thank you.
And if you do have a green sleeve, then you should be putting a copy of your personal directive in the green sleeve.
Okay.
And your green sleeve needs to be stored on or around your refrigerator so that the EMTs can find it if they're coming to your home.
Yeah, and that is more common when somebody is of advanced age or dealing with health conditions. I see there's some questions about uh, whether an agent under a personal directive or attorney under an EPA is entitled to see the will. That's a great question, Allison. Do you contemplate any of that in your documents?
Uh, the once the and I'm of the view once the enduring power of attorney is in effect due to loss of capacity, the attorney can see the will, because you don't want them to dispose of any assets outside of the will. So, for example, Mike, if your will said to give your Harley to Lisa, you wouldn't want the Harley to be sold if you had lost capacity, and that the attorney could actually give those gifts while you're still alive as they're disposing of your personal property.
To be clear, if I have a Harley, I'd lost capacity already. But yeah, no, and my documents say the same thing. They say that the attorney can see a copy of the will to govern their affairs in accordance with the terms of the will. In terms of the agent under the personal directive, I don't know that that would be necessary. The only issue I could see there, and it depends who's making the documents. So sometimes, and I've seen in older wills, people will have in their will an organ donation clause. Generally, I don't put those in wills because wills don't get looked at until it's
It's
too
too
late.
late.
Mm.
Yeah. So I offer clients the option to put it in the personal directive, or I often counsel clients to do that with their driver's license renewal. The little heart on your driver's license indicates that.
Right. And I will counsel clients to put in their personal directive because once you're looking at the will, it's
Yeah.
often way too late.
Way too late. There was a question on that aside of the Mike's Harley that he's just bought, but someone just said, if how does one address the situation where an attorney needs to use or dispose of assets to pay for the care of an incapacitated individual, but those assets are either to be gifted to a beneficiary in the will or may result in net deposition to the estate?
The attorney's job is to care for the individual. Obviously, they would need to look at other assets first and maybe dispose of those assets. But if it comes time to the gift in the will might be void, they still need to ensure that the individual is being cared for during their lifetime. And it's something to be dealt with after the fact. With the power of attorney, any interested party can request an accounting of what they have done as the attorney. So the attorney needs to keep precise records of all money in, all money out, and they may be asked to account after the fact if for some reason they had to dispose of these potential gifts in the will.
Yeah, it's a great question, and I'm going to also suggest that if the circumstances are such in that case, it's also likely that the person had not updated their planning recently enough because um, my practice is we talked earlier at the beginning about specific bequests versus residue. I'm a big fan of less is more. The more detail you put in a will with, I want this person to have this, I want this person to have this, I want this person to have this, the more risk of the will not working. Because For example, I do not like saying I want this person to have bank account 12345 I have at Royal Bank. Or I'll use a better example. Bank account 12345 I have at HSBC. Well, HSBC doesn't exist anymore. They got taken over by Royal Bank. So that gift fails because and someone hadn't updated their will. So I'm a big fan of pieces of the pie, percentages of the estate. It also then also allows people to. I had a client once, a file where the deceased said, I want $500,000 to go to charity and the rest goes to my wife. And when he died, he had $500,000. That's it. And, so when he made the will, he was a high roller and wanted to do this great thing. But now, in that case, the charity was aware enough to know that the wife would be entitled to that money and repudiated the gift. Lisa, you might be familiar with the charity I'm speaking of. Um, so, uh,
I'm familiar with this file.
yes. So,
I don't
so
know why.
I, yeah. So that's why I think the more specific gifts you have in a will, and especially a monetary value, the more risk of that circumstance coming up.
Fair.
We talked a lot about the executor and who to, pick wisely, and because it's a big job. But someone's just asked if they don't have anybody really to be their executor, and their estate doesn't really have money to hire a professional executor. What is the option? What happens to them in that case?
It, I would, if they're doing their will, if they're not sure who to appoint as the executor, they may want to consider one of the beneficiaries of the estate to be the executor. Obviously, one of the beneficiaries would be benefiting from the estate when the time comes. That could be an option. Um, there are, other than trust companies, I know there are some other people that are willing to be private executors at lower fees, but it's just really exploring the options. But sometimes maybe it's a friend or other family member that you would think could do a good job. Um, I, it's just kind of sourcing it out and figuring out who might be the right person.
Yeah, I was going to say the beneficiary to me would be the obvious choice if there's enough assets to do that. Um, but it can be challenging because yes, trust companies. The other thing you can do is you can appoint somebody, and I think Allison probably has a similar practice. And the wills that I prepare have the ability to appoint what's called an agent executor. So the person can go and hire a trust company to act on their behalf to do the work necessary. And that way the person can decide if it's worth the money or not, or if there's sufficient assets in the estate. And something the trust company people might not like me saying is they can also haggle. At that point, they can go to the different trust companies and say, I need help with this. What are you going to charge me? And there's a lady I know in, I think out of Calgary, who part of her business model is to shop around those types of files to trust companies to see if they can give a better rate. And because some trust companies prefer things that are dealing with investments or property or etc. So it depends on that. I saw a note, one of the questions, and this is inevitable, I think, in these situations. I don't blame people asking what the fees would be for doing estate planning documents. And I mean, I think uh, we're always careful when we talk about fees because everyone, I mean, the joke I heard years ago was, what do you charge for a simple, straightforward real estate deal? The lawyer I knew said, oh, they're free. I said, free? And he said, yeah, because I haven't seen one yet. And so it's a little bit like that with estate planning. Everyone is different. Um, I think generally, to give people a ballpark, and Allison, you feel free to tell me I'm out to lunch here. to do a will, enduring power of attorney, and personal directive for an individual, very basic, not a complicated situation, you probably should budget around $1,500 ish. And to do them for a married couple with similar provisions, probably between two and $2,500. Is that sort of the ballpark you're at, Allison?
That would be the ballpark. Yeah.
Yeah. And every lawyer is going to be a little bit different. And then I do also tell my clients that, there's sort of that base fee. And then if it gets more complicated, it's going to add some hourly rate component to it, depending on what it is. If it's a child who's got a dependency issue and they need a trust set up, or if it's a disabled adult child, those can get quite complicated.
Blended
Um,
families.
what's that?
Blended families.
Yeah, blended families, those can be quite complicated. Um, I mean, simple and straightforward is much less common these days.
I don't think, well, and everyone's different. Like, no two people are the same. So why would we expect that any two wills are the same? And
Yeah.
I think when people tell me what one person has quoted for legal fees to do a will, EPA, and PD, and it's like they can get all three documents for $250. I was like, well, you get what you pay for, and I really don't know what's going to be in that. I know I recently had one reviewed a will because we were updating, and this individual, he's in his 50s, single, never been married, and there were all these clauses in his will for guardians and payments to guardians. And I'm like, but you've never been married and you don't have kids. He was like, yeah, I was wondering why that was in there. And it was just whoever did his will took the template and threw his name in, and that was the will.
Uh,
Um, when
Go
you
ahead,
spoke
Lisa.
about a couple, so there was a question just asking, like, can me and my partner do a will together? So together on one document instead of separately. I'm assuming no, but
Uh,
I am familiar. I know there's a family law lawyer out of Calgary that does those as a joint will. I'm not a fan of them because I think you should have testamentary freedom and be able to do your own will and update as you see fit.
yeah.
Um, so I think everyone should have their own will, but I am familiar with some lawyers, and it was specifically a family law lawyer that did these joint. Have you seen one, Mike? It was a
No,
joint.
I
It was
think
very
I think
weird.
I charge double because it sounds way more complicated than doing
Well,
two.
that way, if one spouse dies, they can't change their will.
Oh, you're talking. Oh, so yeah, so I think there's two things we're talking about. There's uh like this person was talking about just doing one will, I think was
one
the,
will for both
as
people.
opposed
Yeah.
to mutual wills. And
Hmm.
mutual wills are a contract that says this is the will for both of us and neither of us can change it.
Hmm.
And so the will doesn't have to be identical, but they can't change the will if one of them dies. I think that's to combat the exotic pool boy who might show up
That's
and
disappointing.
so I knew that would touch a spot on you there, but
The pool
I
boy. It's
I
always the
saw
pool boy.
yeah, well, you got to have a pool, right?
Yeah.
Um, I saw one question there that talked about who pays the bills of an estate while an executor is trying to get the estate in order, and it's a great question and sometimes a problematic question. Um, Generally speaking, what I tell my clients is that they will have to, if the bank will pay the bills, then you would get the bank to pay them. I've been through this before. Depending on the bank, depending on who you're dealing with, I'm not going to name names or banks.
And it depends how nice you are to them when you go up to the counter.
Maybe for you, maybe for you.
Well, no, I had one that started yelling at the teller, and the teller
Oh,
was not very friendly.
yeah. And here's the other one. If you're in a small town, if
Oh,
you're in
small
a
towns
small
are good.
town, they will bend over backwards and help you do everything. If you go to the main branch in downtown Edmonton, they're not going to help you at all, generally speaking. So, what I tell clients is if the bank will pay the bills, that's great. But I had to do this. I'm an executor for a friend, and the bank, I knew the bank would pay the bills, and I asked them to pay the bills. And after about a month, they said, "We can't be bothered to keep paying these bills. You're going to have to deal with it." And so I was quite disenchanted. That same bank, by the way, when I went and met with them and brought them the will to deal with the estate and brought them the grant of probate, they looked at me and they said, "Okay, well, now you're going to have Michael Simons come in and meet with us." And I said, I am Michael Simons, and I am meeting with you. Uh, so the banks are challenging. If there's bills to pay, utility bills, etc., I always tell people, unfortunately, they may need to front the money and claim back. They get fully reimbursed, but their job as an executor is to preserve and protect the assets of the estate. You can't have the gas being turned off in the middle of winter in a house. Allison, now sometimes, Allison, do you ever have clients that want to set up a, I hate using the word slush fund, but but they do some advanced planning with that?
Where they have some money set aside to pay bills. I
Yes.
have had that some money set aside to pay bills. Yes. I'm the executor for my uncle's estate right now. My uncle passed away in November. And so I ended up at one financial institution in the spring to try and get the money. And they set up a meeting. I went to the meeting, and the guy's like, I've never done this before. And then spent the next hour looking through the helpline for his financial institution. I was like, "Do I need to sit here for this?" He's like, "I guess not. I'll I'll get back to you when I figured this out."
Yeah,
It was
it's
super
quite
helpful.
Yeah, it's quite frustrating. I have had situations, and more common when it's someone who's elderly, where they'll say, "Okay, I'm setting up a joint bank account with my daughter, who's going to be my executor. There's $10,000 in it. When I die, she can use that to
Pay bill.
pay bills, pay funeral expenses, et cetera, et cetera." And generally speaking, I think that's fairly efficient and effective. I prefer clients to tell me that so I can have that on my file so that it's known that that's being done for convenience purposes and not inheritance purposes.
Yes.
There was a question about, well, charitable donations and who gets to see the will afterwards. So the question was, if I donate to leave gifts to a charity, do they have the right then to see the whole will?
Uh, Allison, go ahead.
Yes, a specific. So that would be a specific bequest beneficiary. They are given a copy of the whole will as part of the notice for the application.
Okay, and all the accounting and all that stuff as well, they
They're
can
not
see.
given the accounting, they're given a copy of the will, but if they're receiving a bequest of $20,000, then they get their bequest and then they just sign off that they've received it. But with the once the application for the grant is submitted to the court as part of their notification that they're a beneficiary, they get a copy of the will. It's only the residuary beneficiaries that who is receiving the rest of the estate, they get the full accounting.
And something to keep in mind is that when you get probate, the will is public. I mean, people theoretically can go to the courthouse and conduct a search and get a copy of the probate and the will. Now, practically speaking, it's cumbersome, time consuming, and somewhat expensive. So it's not common for that to happen, but it is a public document. I have had situations, and maybe more to that question isn't just about a copy of the will, but that I have had clients that consider doing charitable gifting, and they are debating between a specific gift or making a charity part of the residue. And as Allison said, um, when you make a charity or any nonprofit or anyone who's getting a part of the residue, they have all the same rights as your children who are getting part of the residue. So sometimes people don't realize that. And there's a history, if you've ever gone to the Timms Center at the University of Alberta, That was an estate fight between the University of Alberta and the children of the Timms family. And University of Alberta was the 800-pound gorilla in that fight. And that's why all that money got used to build the Timms Center and not to the kids. So something to consider is who you're naming as a residuary beneficiary and the rights they will have under a will.
Interesting. Someone said that in one of the in-person sessions they attended, it said that they can gift any amount to anyone with no tax, but they were under the impression they could only gift up to $10,000 without tax. So they're just looking for confirmation.
So in Canada, there is no gifting tax. There is gifting tax in the US, and I don't know what the specific amounts are now, but in Canada, once you receive, so when someone passes away, it's deemed that they have sold their entire estate at fair market value the moment before they die. This is a taxable event for the purposes of paying tax to our friends in Ottawa. And once all the tax is paid, the beneficiaries of the estate receive the after tax dollars. So if the gift is $20,000, they receive that $20,000 tax free. And then if they then turn that $20,000 into $40,000, they would have to pay tax on the gain, the increase in value of the gift.
Yeah, and it is, I mean, you can gift whatever you want, as Allison said. There's not a gifting tax, and there's also not inheritance tax in Canada.
Okay. Um, so this is a question about, like, it's funny you mentioned safety deposit boxes and not to leave your will in there. Um, I can tell you my mom has hers in her safety deposit box right now. I just I will be changing that right after. But this question is about other things in the safety deposit. Said I'd like to have my child have joint access to my safety deposit box for administrative purposes, but that child would not be the sole beneficiary of the items in the box. So how do I ensure other beneficiaries receive their share of the assets? I feel like you've answered this in terms of the planning, obviously what the will says, and also to be upfront with your beneficiaries about what you've written in there. But it just said, how do I protect those assets from the child's creditors or matrimonial property? Is the other side of this, and is it different if it was a bank or investment account?
I That's a tricky question. And the
Okay.
reason it's a tricky question is, let's say you had a safety deposit box, and in that safety deposit box, there was a diamond ring, or three diamond rings, and you wanted one to go to each of your three children. Um, and you put it in your will. I want one of each of these diamond rings to go to my children. That's pretty clear. I have had some debates with banks on how a safety deposit box is characterized when it's held jointly. And I once had a bank tell me that a jointly held safety deposit box goes with survivor benefits. So if Allison and I have a joint bank account and I get hit by a meteor one day, the typical joint bank account has survivorship. So Allison would get the money in that bank account. Even if I had a will saying this bank account goes to the Edmonton Community Foundation, uh, the survivorship would trump that. And my concern in answering that question is that I've had a bank tell me they have the same rules applied to a jointly held safety deposit box. So I would be concerned about that, and I'd want to clarify that with a bank before putting someone on as joint on a
Got it.
safety deposit box. Allison, have you had any experiences with that?
I have not had any experiences with that, but I know the banks don't really understand the rules with respect to joint assets being held with a child. Um, and the rules are if an asset's held jointly with a child, it's just the presumption is that it is just being held jointly for the purposes of the estate. and that the child needs to prove it is a gift. And if the child can't prove it's a gift, then it forms part of the estate. But again, if you're doing this, it could potentially create a whole bunch of litigation, which Mike and I may think that obviously this is a plan gone wrong.
Yeah.
So I would not be a fan of that. The power of attorney, the enduring power of attorney itself could give access to the attorney to have access to the safety deposit box. I know that's in my document, Mike, I'm assuming it's in yours too. So that once the person has lost capacity, that the attorney could go in and then have track of what is in the safety deposit box. But I don't think I would put the child on jointly. Again, I did have a file where some jewelry accidentally disappeared after the deceased died, not to be found again.
Okay. So would that happen when you say like it's also equally as complicated if you put your child on like a bank account as well for those reasons? Like that's we're coming into the same similar
Right.
issues.
So sometimes the child will start to treat their bank account like their own, even though it's the purposes of helping mom or dad pay bills. And that's where it's, yes, it's a plan, but usually it is a bad plan because it tends to create more litigation after the fact. It's having the proper enduring power of attorney. So if they need some assistance now, have the power of attorney come into effect immediately. And then that can be placed on the person's accounts now so that they are acting as attorney and not as a joint holder. I do find financial institutions don't really understand the law and they just think, well, once someone passes away, the bank account passes by right of survivorship. And that's where disputes come into play because the child's like, well, no, mom put me on the account. It must be mine. So I'm taking this $100,000 and next thing you know, they may have spent it or done other things with it. And we're trying to have to recover it.
Right.
And the person who asked the question also talked about keeping it out of matrimonial property for the child.
Right.
And sometimes people try and be too smart by half. They're like, oh, I'll put all my kids on my bank accounts and I'll put all my kids on the title to my home, and that'll avoid probate and I won't have to pay those lawyers all these fees. And then everything goes sideways and somebody gets divorced and there's a claim, and sometimes you're better off, well, sometimes, almost all the time, you're better off following the easiest path. The only time I've seen that work, and Allison sort of made the joke about, not having a crystal ball and knowing when you're going to die, and without wanting to be morbid about this, I have had files where someone is accessing medical assistance in dying, and they actually know the day that they're going to pass, and they have capacity, and they gift everything to their children the day before they pass away. And it can be, it didn't save money or work, it just saved um, time for the children, essentially. So there are some unique circumstances, but that's obviously the rare exception, not the rule.
Okay, I am very aware of time. It looks like we could have talked for another 2 hours with all the questions that came in. Okay, it is 11:28. Did you have any kind of closing thoughts? I apologize to anyone whose questions we couldn't get to today, but any closing comments, thoughts, ideas? One thing you should do, get my mom's will out of her safety
Yeah.
deposit box. That's my
Yes.
takeaway.
Well, no, thank you to the Edmonton Community Foundation for again putting on Wills Week. I appreciate that you've invited us to attend again and speak again, um, even though Mike wants to break up the band.
No, 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 no.
We appreciate the time. We appreciate all the questions that were asked. They're very thoughtful questions, and thank you for having us.
Yeah, I want to echo that, and I want to say to everyone who's watching, apologies if we couldn't get to your questions. There are a lot of them, and some of them are pretty fact specific or unique, and they're not things we can necessarily address in this forum. But more importantly, I want to thank the Edmonton Community Foundation. Um, I think of all the good work the ECF does, one of the bad things they do is they don't brag about themselves, and they do incredible work for our community. And Wills Week is just a very small part of it that we are part of and privileged to be a part of. And if you're considering doing planning and doing charitable giving, I would encourage people to investigate the Community Foundation. It is a tremendous way to make the impact of that giving felt for a very long time.
Thank you for that. Well, thank you both, as always, for taking time out of your day to share your knowledge and to answer all the questions that we could get to. And on behalf of the foundation and all of the Volunteer Wills Week committee, I'd like to thank everyone for attending this session, all the sessions this week. I hope you found it informative and helped answer some questions for you in preparing and updating your wills and estate documents. Remember to fill out the evaluation form when this webinar closes. It will pop up on your screen. And just, yeah, thanks you on behalf of all of us. Have a great day and a great weekend. Thanks again.
Thanks so much. Thanks, Lisa. Thanks, Allison.